Good morning, everyone.
Good morning.
Good morning to everyone here in Carson City, as well as those in Las Vegas, and of course, anyone watching online through Nellis or through our YouTube legislative station. If you are on Nellis, you'll see our agenda for the day. We have two bills, and on that agenda, just trying to get to it so I can give you the phone number for today. The phone number is 888-475-4499, and the meeting ID is 829-617-75123. And that's for anyone choosing to make public comment or testify over the phone. We will have public comment at the end of today's meeting. We ask that anyone making public comment or testifying on any bills keep their comments to 2 minutes each, and anyone presenting bills keep their presentation to 15 minutes each. Of course, our friendly reminder, please make sure that you turn off your electronics, as well as making sure that before you speak, you state your name and spell it for the record. And with that, Committee Secretary, will you please take the roll?
Assembly members Cole. Dahlia. Here. Gonzalez. Here. Gray. Here. Hanson.
Here.
Hardy.
Here.
LaRue Hatch. Marzola.
Present.
Moore.
Here.
Nadeem. Ortlicker. Roth.
Here.
Urick. Here. Chair Miller.
Here, and please mark LaRue Hatch present when she arrives. And Assemblymember Ortlicker is walking in. Please mark him present as well. And I'm not sure where Nadeem is, but her folder's here, so we'll. So please mark her present when she arrives. And with that, we have two bill hearings. We'll open up the first bill, which is from Assemblymember Cole. It will be Assembly Bill 384. Which revises provisions relating to juvenile justice. And so, Assembly Member, when you are ready and settled, you may proceed.
Good morning, Chair Miller, Vice Chair Marzola, and fellow committee members. I am Lisa Cole, and that's spelled L-I-S-A-C-O-L-E, and I proudly represent Assembly District 4 in Northwest Las Vegas. I'm joined today by my co-presenter, Bridget Duffy, who is the Clark County District Attorney for the Juvenile Justice Division. Ms. Duffy will be co-presenting from Las Vegas. Chair, first I would like to thank you for giving me the opportunity to present this important piece of legislation. Juvenile justice issues are not easy to legislate. They require very deliberate and careful balancing of fundamental rights for multiple people. The rights of the youth who has committed an offense and is now within our criminal justice system, the rights of the victims and their families, the rights of other youth offenders who are also detained together in the facility, the rights of the counselors, nurses, supervisors, teachers, and staff of the facility, and the rights of the public when a youth offender is discharged. Right now, you may be thinking to yourself that this bill will lead to further criminalization of at-risk youth who have had the deck stacked against them, and what I propose will only further harm these vulnerable youth. I assure you that is not the intent of this bill. In fact, this legislation seeks to do just the opposite. The goal is to ensure our juvenile justice system does its job for all the youth who enter, including those who, despite the best efforts of juvenile detention facilities staff, do not work the program and learn from their mistakes. The goal is to ensure that these youth are placed in the right programs while they are still within the juvenile justice system, where programs are designed intentionally around rehabilitation and not punishment, where the focus is on understanding root causes of bad actions, teaching coping skills, and providing counseling and mental health treatment as needed. and to prevent them from entering the adult criminal justice system, which is much harsher. Like many legislators, I am presenting this bill because of something that occurred in my district: the intentional hit-and-run murder of Andreas Probst, a California police chief who moved to Las Vegas with his family after retiring. The perpetrators brazenly posted videos of the crime spree, which involved stealing multiple vehicles that they then used in hit-and-run of not just Mr. Probst, who was killed, but also another cyclist and a collision with a vehicle as well, all within Assembly District 4. Both perpetrators were juveniles who were adjudicated as adults. Now, because of the traumatic nature of this event, Ms. Duffy and I have decided not to present video footage to the committee today. We don't need any more trauma here. Instead, we've provided the YouTube link to one of the news stories so that anyone who wishes to can watch it for themselves. But what struck me most about this story was the casual attitude and laughter they intentionally harmed others, and the statement by one of the perpetrators that was caught on body cam: "You think this juvenile," expletive, "is going to do something? I'll be out in like 30 days. You bet." That statement is clear evidence that this 17-year-old had been through the system many times and was not benefited. Our juvenile justice system is complex, but the overarching goal is to rehabilitate youth offenders. Nevada recognizes that young people are more capable than adults to change, that youth offenders are likely acting out because of serious trauma that they've experienced and may not have had the support system that others have had to deal with those issues. For most offenders, our system works as intended, but for some, it does not, and they continue to act unlawfully until one day their behavior lands them in adult court facing decades behind bars. This bill is aimed at ensuring that fewer youth offenders enter the adult system by addressing three main issues: identifying certain behaviors within facilities that are likely indicators that a program is not working, and ensuring such behaviors are properly documented and reported; requiring facility supervisors to provide details when denying placement and ensuring the supervisors assist in finding alternative facilities; and ensuring that community stakeholders and service providers are included in parole discussions so our youth have access to wraparound support systems upon discharge. Ms. Duffy, with permission, Chair, Ms. Duffy will now walk you through the bill and the proposed amendments, which are the result of much work with stakeholders over the last few months and continues now. Thank you.
Good morning, Chair Miller and members of the Assembly Judiciary. My name is Bridget Duffy, Brigid Duffy, Assistant District Attorney in Clark County over the Juvenile Division. My apologies for not being there in person. I was at the airport last night and my flight just kept getting delayed and delayed and delayed. And the snowstorm in Reno.
We've all been there, so
so
we've all been there.
It is not usually my MO to be co-presenting a bill and not in front of this very important and esteemed committee. So my apologies. I did my best. So I'm going to walk you through the amendments, which I believe you all have before you. Starting with Section 1 of the bill, which adds a new section into the definition section of Chapter 62A for creating a definition of an act of serious violence, which would be defined as an act by a child on another child or staff member at a local detention facility, a regional facility for the treatment and rehabilitation of children, or a state facility for the detention of a child. So this would cover local detentions, our camps, Spring Mountain Youth Camp, and China Springs, as well as our state facilities in Elko Caliente in North Las Vegas. The act would have to include the use of a weapon, or it would be a battery that results in substantial bodily harm, or it would be repeated acts of violence that result in disruption to the facility or to put staff or children at risk of substantial bodily harm. Just want to make sure everybody understands this is new and not a new crime. Crimes are in a totally different section of our statute. That's Title 15. This is just an action or a series of actions inside a facility that would occur. Section 2 makes those conforming changes. Section 3 Sub 1 amends Chapter 62E, which is our disposition sentencing in juvenile, otherwise known as sentencing for some people, that's in criminal court. This section would require the regional facilities, state facilities, and local detention facilities, if children are placed there pursuant to Chapter 62E 710, to create and maintain written reports, commonly known as incident reports in the field, documenting the commissions of these acts of serious violence that is committed by the child. Because 62E is our disposition section or sentencing, this would allow the court to know what is going on in the facility and if the program is working or if the child is not amenable to the program in that specific facility. Subsection 2 of Section 3 requires the incident report be filed with the court and a hearing held within 30 days prior to any release of the child from the facility. So before a child is paroled from a state facility or placed out into field probation from one of our regional facilities like the camps. Subsection 3 allows the court at that hearing under subsection 2 then to make determination if the child is ready for discharge. And if the child is ready for discharge at the court's determination, then the court can then determine the aftercare plan for the child based on the needs of the child and the safety of the community. Section 4 makes changes to the disposition statute that allows the court to consider acts of serious violence when determining disposition of cases or sentencing again. Section 5 amends 62E 505, which requires the court to consider things prior to committing a child to the state facility. There's current language in there that it requires the state to consider if there's any less restrictive placements. So now, in addition to the existing language, we would have the court consider serious acts of violence in determining whether or not to commit a child to one of the state correctional facilities. Section 6 would require the Division of Child and Family to consider those serious acts of violence when developing their length of stay matrix and establishment of release criteria. Section 7 is being recommended to be struck in its entirety. Section 8 addresses the requirements of our Youth Parole Bureau under NRS 63-710 by adding the requirements that the Youth Parole Bureau would communicate with schools to ensure the child is attending and receiving proper counseling and guidance. Section 8 also creates a task force to facilitate wraparound services that are available to children being discharged from state facilities onto parole or juveniles that are placed on probation. That task force would require partnerships with recent programs, mentorships, workforce trainings, and the partnerships could include private or public partners as well as grantees or sub-grantees. Section 9 amends 63-400, current law, that allows a superintendent of a state facility to accept a child, well, it mandates they accept a child, unless the superintendent determines that there's not adequate room or resources in the facility to care for the child, there's not enough money to support the facility, or if it, in its opinion, the superintendent's opinion, the child is not suitable. So this is a section where a court would commit a child to state custody, DCFS's custody, and then the superintendent of the 3 facilities that we have could determine there's no adequate room, resources, money, or the child's not suitable. So section 9 would add in subsection 5 a section that would say that in according to subsection 1, if in the superintendent's opinion the child is not suitable for admission, then the superintendent must provide the court, the child's attorney, and the state with its reasoning for the opinion and provide proper documentation for that opinion. Then in section 10, it amends 63.450 to say that if the superintendent determines that the child is not suitable, then the Division of Child and Family Services administrator needs to locate and secure an alternative that provides that same level of care and treatment as ordered by the court. And I definitely can go into that more when we get to questions to kind of understand that process for you. In section 11, 62E507 requires that the length of stay and release criteria consider any acts of serious violence committed by the child, so prior to being paroled into the community. And then we have some friendly amendments that I can mention from our partners at Boys Town to amend some things into section 8. They would like to amend into Section 8, among other things that we're addressing with regard to school, that guidance services and supports are offered by the school district to partner and coordinate with available organizations that offer evidence-based home and community-based services for the child, as well as reentry programs that are evidence-based and informed for reentry, meaning reentry is when a child leaves a facility and is re-entered into the community, specifically into schools. We call them reentry programs, and other necessary services for children and their families, making sure we include families in those services. Also adding a new subsection 3 to Section 8 that would have a partner and that would allow partner and coordination with available organizations that offer evidence-based home and community services for the child and family, and entities who offer entry programs. That are also evidence-based and informed for reentry mentorship and other necessary services for children and their families who are paroled, as well as in Section 4, having the task force identify and make available wraparound services for children and their families by partnering with all the available organizations. So that concludes my walkthrough. I want to, before I ask to take questions, I want to go back kind of to my testimony where I saw you all last week and what I see as being very significant in this system. Our system is supposed to be addressing the needs of children to help them change their life trajectory, to get them on the path of having a good life. Not a perfect life, because no one's life is perfect. In the juvenile system, we've learned we measure success very differently than we may in other areas of life. You know, if a child, for example, if a child's not attended school at all and now they're attending school 60% of time, like, we cheer that as a success. And that's because it is. It's better than what it was, right? We're getting them better than where we met them. And where we met them was at a point in their life where they're facing detention, they're facing correctional care, and they're in need of services. Our goal is really to stop sending kids to the adult system. It's not, my goal is not to motion the court to certify more kids and throw them away. My goal is to stop that. But what we need are some different parts of our system to do a little bit more and a little bit better to prevent that. Because what I see in my role as a DA is the children that are coming back and coming back and coming back till we get to a point where we've exhausted everything we've had. That's where we start looking at whether or not the adult system is what's necessary. If a child keeps coming back, or we get to a point where we have nothing left for them, then we have failed because we've given them every opportunity the system has. I've recently spent time with two amazing judges from our criminal division, so our adult system. One who is a former DA, one who is a former public defender. And we went to the prison in Carson City, the Northern Nevada Correctional Facility, to speak to the children that had been certified by the court and tried in the adult system or negotiated in the adult system. And we were able to have conversations with them about what it is the juvenile system could have done better. A common theme among those children where they didn't feel that they were being watched. They hardly ever saw their officers. When they were on supervision, it wasn't really supervision. Another thing that was very obvious was the anger that our kids carry, which you hear, we refer to it as trauma. It shows itself in anger. And they lack a lot of empathy for other people. There's a lack of empathy. That is what we're seeing. So I think a lot of these bills that you'll see me coming forward to this table on, and very willing and looking forward to the questions and the good conversation, are all about pieces of our system that we need to improve somehow, some way, to prevent those cases that end up in the adult system, where children have less of a chance of rehabilitation and ultimately a good adult life. I said last week when I testified that we need to treat the child and not the crime, and I really mean that. But that means having information. That means we know what's going on with that child. And all these little silos that we have have information, but they're not all necessarily getting to the court or to their defense attorneys or to the state. So we need to start picking away at that to create a really good system so that we can prevent that recidivism and keep kids in the juvenile system and send them on a better trajectory in life. We don't want to drop the ball. And that's where this bill comes in as a whole nother piece of where we can gather information, make sure that children are in the correct facilities, getting the correct treatment, to help change that path where they are now and would be kept by the statute, so that we then don't get to a place where they are heading to the adult system. So I appreciate the opportunity to present today, and I look forward to any questions that you may have.
Thank you so much. With that, I will go ahead and with questions, we will begin with Assemblymember Roth.
Thank you so much, Chair, and thank you so much for the presentation. I appreciate accepting the friendly amendment from Boys Town. One of my concerns with the bill is that it seems like there's two parts, right? There's a little bit of ensuring that there's services which are necessary to ensuring that our kids are able to rehabilitate, but there's also a bit of a hammer. And my concern is that we don't have the wraparound services or programs that are really necessary for this to succeed outside of Clark County. So have you had any discussions with the rurals and Washoe County about what programming is available, so that what I think seems to be the whole crux of this bill is to ensure that we are rehabilitating, but I don't know if those programs exist, and so my concern would be that this just ends up being a hammer.
Lisa Cole, for the record. Bridget, would you like to take this one?
Yes, thank you. Bridget Duffy for the record. So I'm going to, I just want to make sure I'm breaking down where you, Assemblymember Roth, are seeing the hammer. Is it specifically within that Section 8 of requiring those types of services be put around the child and talking about? I just want to make sure I clarify where the...
Yeah, so, and please correct me if I'm wrong, but I'm reading this bill as that there is a natural punishment or consequences to not engaging in programming. So, it creates a system where we need to document and report whether or not kids that are in the system who are severely traumatized are responding to and engaging in different treatment programs or options. And so my concern is that when there is a natural consequence to not engaging or responding to those programs, has there been discussions about what programming is actually available that is evidence-based outside of Clark County?
Thank you for clarifying that. This Bridget Duffy for the record. With regard to this bill, I have not had specific conversations with the rurals or Washoe on what services are available. I think I would hope they're here today, although I expect, because we still have some work to do on some of the language within the bill, they might be coming in opposition and they could answer those questions. I do know, just from being around Washoe County a lot in many different organizations, like our Juvenile Justice Oversight Committee, they do have mentoring services, therapeutic services. I mean, every jurisdiction has a school district that we can work with to make sure that the child is attending school and what they're getting in school is needed. I don't know about workforce training specifically. We do have a very robust program in Clark County for that, for youth, but those questions maybe could be helped answered by our jurisdictions that I believe might be present to talk about this bill today.
Lisa Cole for the record, just to add a little bit to that, I think you bring up a very good point as to the rurals. I have had conversation with Washoe about some of their programs, and I think that they're doing a pretty good job for what they have. I think that we could add the rurals in as a component to this. Some of it might have to be, telehealth kinds of things and counseling. But I think the point is that the natural consequences now are that these kids are being released and those wraparound services are just not there. So this task force or a working group that we're going to create is actually going to help foster those resources so that we're building upon them. And it won't be available right away, but more and more and more will be available to help. And hopefully that answers your question. Thank you.
Thank you. Our next question is from Assemblymember Hardy.
Thank you, Chair, and thank you for this bill. And Ms. Duffy, I know since my time here in the legislature, your work with juveniles, that your heart is definitely in the right place. And I think that, we all agree that the more that we can do with these kids to address the underlying causes and keep them from going into the adult system is the goal and the best thing here. So, Assemblymember Cole, you kind of started to touch on my question with the task force. So if you could just maybe expand on that a little bit, why you think that's important, why that was added. Is it to kind of have some coordination with the services, or just if you could speak to that importance of that piece? Thank you.
Absolutely. Thank you very much for the question. Yes, the goal is to create a system where we actually have both the public groups, the facilities themselves, and private organizations and other groups come together and have conversation about what is the need, how do we provide for those needs. In conversation with some of the stakeholders, including some folks out at Summit View facility, which is in Las Vegas, and it's the highest maximum security level for the juvenile detention facility. The wraparound services were something that they spoke of that is a huge need, and that's in Clark County. So that need is throughout. And Clark County does get, in that facility, they do get from all over the state. So whatever we can do to help these kids when they get out is what my goal is, to start those conversations and have it be meaningful. Thank you.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for presenting today. So as a teacher, I teach high school, I have had students that are on parole or probation. I find out because the student tells me, right? Nobody else communicates with the teacher. They don't have to tell me, of course, but oftentimes they are very, very nervous about making sure they're marked present because their supervisor, somebody's checking on them and they have to make sure that they're in school. And so I just wondered, can you speak to what is being done? Are people looking at their Infinite Campus and making sure that they're attending, checking their grades? And what do you envision with this change in the bill, especially I'm looking at the section, obviously talking about coordinating with schools. Are you envisioning direct coordination with teachers, or is that more of a high level we're just alerting the school district?
Lisa Cole for the record. We've had a good conversation about this, and I look forward to having more conversation. Right now, there is in statute the requirement for if a child is involved in a family event where, say, there's a problem at the home and the police are called for a traumatic event, that at least the administrative level of the school is notified of that, so that if there are any disciplinary issues that day for that child, that they're not pulled into having problems, right? But it's not getting down to the teacher level. So I want to have more conversation about how we can do that, still understanding that there's respect for privacy, right? So we have to tread lightly on that and figure out the best way to do it. But yes, my goal would be for the teachers to know. And for me, it might be that the teacher goes to the administrative and just say, hey, maybe weekly, maybe monthly, like, where are we at? Has anybody been adjudicated and released? Do we need to know about this? But I appreciate your input on this, so would be happy to have a conversation. And I don't know if Bridget has more conversation about that as well. Thank you.
So Bridget Duffy for the record, thank you. And thank you for the question, Assemblymember LaRue Hatch. So, first of all, part one of your question, I guess, there is no sharing of Infinite Campus and Parent Portal or whatever that is. We have issues because, FERPA this, FERPA that. It's just conversations with the school. And I'm talking about it from from a parole probation place. For our children in foster care, it's different. There was an amazing program when children were released from Spring Mountain Youth Camp. I think that the true belief is that kids who are separated from school, every day they are separated from school, it's very difficult to reintegrate them back. That's why kids who have poor attendance, they just don't do well because they're disengaged, they're, suspensions, expulsions. So there needs to be those, what we call reentry programs. And Spring Mountain Youth Camp had a really good reentry program with schools where they had a certain school district employee that would make sure that when a child was discharged from Spring Mountain Youth Camp onto probation in the community, that they were the liaison to make sure that the school knew. Plus, these kids are in school while they're in these facilities, so their credits are getting caught up, making sure that they're back in the proper classes. So that kind of interaction, it goes a long way for the success of students. There has been a very ongoing long debate about how much information schools should get, because there's a school of thought that if we let schools know that a child is on probation or parole, they're going to treat them differently. They're going to look at them as bad, for just a simplistic word, rather than look at them as support, and rather than look at them to support them to make sure that they get on the right path. So I think that debate is still ongoing. How much information do we want a school to have so that a child isn't, flagged and constantly watched? In a perfect system, there would be this embracing of a child, this reentry program, this making sure that they're in school, because that's a really big indicator of success in the future education, being in school. And that transition would be really important. So I think this task force, the thought of it is, let's get the people at the table, and whether it's a student success officer, as we call them in Clark County, that's assigned to each, facility that can help them step down, and they are involved in the process in these meetings, that would be a first step.
You're welcome. Our next question is from Assemblymember Nadeem.
Thank you so much, Madam Chair. Thank you for the presentation. So my question is that, have you done any research beside the school scenario? Is there any other services that can be provided to those the kids?
Ms. Duffy, would you like to take this one? I think you
Yeah.
probably have better knowledge. Thank you.
Bridget Duffy, for the record. Yes, thank you for that question, Assembly Member. We have, in Clark, we are fortunate, although we need more for the amount of kids that we service. We have mentoring programs. We have life skills programs, coping programs, anger management programs. We have a drug court or outside drug treatment programs. We have a variety of things that are in place to help these children succeed. The nice thing about requiring a team get together and wrap themselves around a child is that everybody knows what everybody else is doing to make sure that child's on the right path, right? Again, I go back to, we're dealing with kids, and if one parent knows one thing and another parent knows another thing, and those two parents don't talk, then that's a breakdown for the child, and the child, one, thinks they might be able to get away with something. And I'm just talking about children like my own, like not children who are in the system. So any child. So being able to have a place, whether you call it a task force or you call it something else, that is reviewing what the child needs to be doing to be successful together, so they cannot be, separated, bifurcated. One knows one thing, one doesn't know the other. I think is a better recipe for success for a child. In statute for probation, we have requirements of case plans for children that have to be reviewed every 90 days. And that to me is very similar to what this task force would be doing, looking at the plan for the child, reviewing it, and making sure those things are in place while we get this child on a road to success. So we do have services in Clark that would be able to do that.
Thank you.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair, and thank you for this bill, and thank you, Ms. Duffy, for being here and helping present. You mentioned, was it Spring Mountain facility had a good reentry program, but it sounded like in your comments, and I'm sorry if I stated it wrong, I was typing my notes and they've disappeared. So the facility you mentioned had, past tense, is it still in operation?
Bridget Duffy for the record. I believe it is still in operation, but I will have to double check that. My experience with it was on several children that I had worked through the foster care system where I was the mentor to them. And so I was meeting with the reentry counselor at the high schools on those services. So, and then I know that individual had retired, and I have not met the new individual that they've assigned, but I'm sure they're all listening today and would be happy to check in and tell them this great program that they still have on that reentry.
Thank you for the follow-up. Thank you for that. And yes, if somebody is listening, it'd be nice to maybe get on the record what are some of those things that help with reentry. And I just wanted to speak to the point regarding some of the rural resources. I mentioned quite often I have 6 counties, and I haven't talked to anybody about this bill currently, but just having been engaged in the community, there are a lot of community resources, so boys and girls clubs, I think Boys Town has a presence in some of these counties, and my engagement with constituents has been the idea of telehealth, of course, would be wonderful, but I really feel like we could get good engagement with this task force idea, because rurals are much like urban. We all care about our kids and want to be engaged, and I think those resources hopefully are there. I've seen some of them, and to the degree that they could roll out, I have a certain set of confidence, but certainly we'll check in with the rural component if we don't have some representation here today to speak to that. So thank you for being thoughtful about that as well in your concerns.
Thank you so much, Assemblywoman. I appreciate the help, and I look forward to having conversations about those and make sure that they're included on the workforce. Thank you.
Okay, thank you. Not seeing any additional questions, I will go ahead and open it up for testimony. We will start here in Carson City. Anyone wishing to testify in support of Assembly Bill 384? Not seeing anyone. Is there anyone there in Las Vegas? Okay, not seeing anyone. Broadcasting, will you open the lines, please?
If you would like to testify in support of Assembly Bill 384, please press star 9 now to join the queue. Caller with the last 3 digits, 389, you are unmuted. Please begin when ready.
Good morning, members of the Assembly Judiciary Committee. This is Jennifer Noble on behalf of the Nevada District Attorneys Association, JENNIFER, NOBLE, testifying in support of Assembly Bill 384. We'd like to thank Assemblywoman Cole for bringing forth this important piece of legislation, which will help ensure The juvenile facilities maintain records regarding serious acts of violence committed by youth while they are in the facilities and help ensure that we can get children the appropriate treatment and hopefully change their trajectory by preventing them from ultimately ending up in the adult system. And we echo ABA Duffy's comments and we urge your support. Thank you.
Thank you. Next caller.
Good morning, Judiciary Committee and Chairman. My name is John Etzel, Executive Director of Boys Town, Nevada, JOHNETZELL, testifying in support of AB 384. And again, I appreciate Assemblymember Cole and her efforts to bring this forward, and would ditto the comments from ADA Duffy, and really believe strongly that when we put forth the effort to engage in rehabilitation efforts with kids at this age, the ROI on this from a long-term perspective is significant for all of our communities and for the state of Nevada. And for these reasons, Boys Town is in support of AB 384.
Chair, there are no additional callers choosing to testify at this time.
Okay, thank you. Then I'll go ahead and open it up for opposition testimony, beginning here in Carson City.
Good morning, Angela Knott from the Washoe County Public Defender's Office. So we have been meeting with Assemblywoman Cole, and we've been working on this bill with her actually since the beginning of session. So we just recently got the proposed amendment to AB 384. I've sent it off to our team. Unfortunately, at this moment, we are in opposition, especially regarding sections 1, 2, and 3. At least in Washoe County, we're not as familiar with Clark County, obviously, but we already have a lot of these processes in place, but right now we have a lot of discretion within both of our facilities and with our courts on how we are working with our juveniles. So for an example, when we're talking about the violence and the mandatory reporting of these violence, they're already being reported. And if they're serious enough, they're being charged, right? So you're already getting new charges. So you're not being released knowing that this child just committed a serious violent offense. I was kind of hoping she was exaggerating, but one of our attorneys has a child who is having behavioral issues, but just picked up 40 new battery charges. So they're not being released anytime soon, and they're obviously working with this child to figure out what that child's specific needs are and how to best work with them to make them able to be released without being, to be successful when they get released. One of the other issues that we're seeing in Washoe County is that when they're in these facilities, it's kind of like a mixed facility, right? You have children who maybe have mental health issues, disabilities. Then you also have children who have been raised in the gang life, for lack of a better term. So you kind of have this mix of kids and their behaviors in there when they're sitting, a mental health child next to a gang member, sometimes behaviors don't match what is supposed to happen. So for those reasons, we are in opposition, but hope to continue working with Assemblywoman Cole.
Thank you.
Good morning, Chair Miller, members of the Assembly Judiciary, Paloma Guerrero, PALOMA-GUERRERO, on behalf of the Clark County Public Defender's Office. I want to echo the same concerns from my counterpart from Washoe County. I do want to commend Assemblywoman Cole for opening these conversations with us, and also we really love Section 9, Subsection 5, the creation of the Task Force for Wraparound Services. That's a really incredible, important piece of this whole legislation. Our concerns are mainly around Section 1, the repeated violent acts, and serious violent offenses and how they define that. My counterpart from the Juvenile Division made comments to me about the problem of using just the term weapon of a child, because she has seen a spork being charged as a weapon, so that needs a different definition of either like a serious, like a deadly weapon or a dangerous weapon. Additionally, repeated violent acts that result in disruption of the facility could encompass any sort of mental health episode from people, and right now it's overbroad. But we look forward to continuing conversations with Assemblywoman Cole, and that's it. Thank you.
Thank you so much. Is there anyone else in opposition here in Clark County? I don't see anyone in Las Vegas Broadcasting. Will you open the lines, please?
If you would like to testify in opposition to Assembly Bill 384, please press star 9 to join the queue. Chair, there are no callers choosing to testify at this time.
Thank you. Then I will open it up for testimony in neutral. Is there anyone here in Carson City that would like to testify in neutral?
Good morning, Madam Chair and members of the committee. For the record, Marla McDade Williams, M-A-R-L-A-M-C, capital D-A-D-E, W-I-L-L-I-A-M-S. I serve as the administrator for the Division of Child and Family Services. The division has two components that are in this bill. So we manage the Youth Parole Bureau as well as the 3 detention facilities in the state, which is the very back end of the system, right? We take them after the counties have worked with the youth as best they could, and then courts ultimately make a commitment to one of our facilities. Our superintendents have had a lot of authority to determine whether or not they can meet the needs of the kids in the facility. So just for awareness, this will change that process. I also wanted to address in Section 8, so youth parole's function is to help the youth work their plan. Trying to understand if there is a if they don't work the plan as identified in the statute, does that create then a new crime that would recommits them back? So just trying to understand that. Again, once a youth is committed, we do our best to determine how to manage them. And so we have a proposal to create an intake and assessment facility at our Summit View location that would more intensely allow us to identify assess and evaluate the needs of the youth, their behavioral health needs, their mental health needs, get them into the system for treating them as quickly as we can. So that is just for your awareness. The portion that requires the administrator to take a youth if a decision is made. Now, and a decision is never made. Once a court commits the youth to us, we don't make a decision that we are not taking them. We make a decision about where to place them within the facilities that we have. And sometimes we can't take them as soon as they're committed because we're at capacity in a facility. Physically, we cannot take them in.
Okay, your time is up, but I do have a question for you. And that is to clarify that concern that was brought forward about superintendent, and even earlier in your testimony, you said superintendents do have a lot of flexibility on determining where the youth can be placed. So one of the concerns that's been brought forward is that at times it's perceived that superintendents may use that authority to say, we don't want this youth in our facility because of their record, because of their past offenses, because of their struggles that we may not be able to address, as opposed to we are not able to take this youth because we don't have the space or we don't have the staffing. So could you clarify what exactly is happening and how the superintendents are using their authority for placement?
So at Nevada Youth Training, for the record, Marla McDade Williams, Nevada Youth Training Center and Caliena Youth Center are staff-secured facilities. There's no razor wire around the boundaries. They are cottage-like environments. NYTC is designed for what we'd call lower level youth, right? Caliente, might be a step up. And then Summit View is razor wired around. They have, lock access everywhere they go, gates to open. At some point, if they are at capacity, regardless of whether or not a youth is determined to be there, if a youth is not a candidate for NYTC because they need that more secure level of care, we would have to wait for a bed, if you will, to open up in Summit View to be able to take that youth. Nobody arbitrarily decides that they're not taking a youth. They make those decisions based on the needs and the safety of all of the youth in the facility. So over 100 youth at any given time throughout the state that we are taking into custody. There is a perception that it's arbitrary, but that is the point of we have statutory requirements to evaluate and assess how best to treat, how best to manage those youth that come into our custody. And all of the superintendents take that very seriously. They're evaluating based on their ability to ensure safety for all of the juveniles under their care.
Do the courts not decide where the youth will be?
The courts do not decide, and that is a deviation in this bill. Courts have never decided. The superintendents have always had the statutory authority to determine if they can meet the needs of that person coming in. We are state general fund. We have all kinds of limits. On the Youth Parole Bureau side, right, once they're paroled, we do have programs. I have multiple contracts out in the community to help us manage those youth out in the community. So happy to have further discussions as needed about that as well.
Thank you. I appreciate that. Thank you. With that, and thank you for answering my questions, is there anyone else here in Carson City that would like to testify in neutral? Is there anyone in Las Vegas? Not seeing any broadcasting, will you open the lines?
Thank you, Chair. If you would like to testify in neutral for Assembly Bill 384, please press star 9 now to join the queue.
Good morning, Chair Miller and Assembly Committee on Judiciary. My name is Elizabeth Flores, ELIZABETHFLOREZ, and I am the Director of the Washoe County Department of Juvenile Services. I am testifying in the neutral position on AB 384, but hope to move to the support position in our continued work with the bill sponsor. For information, Washoe County, the China Spring Youth Camp in Douglas County, and the community-based organization, the Children's Cabinet, have entered into a partnership called Positive Pathways to Reentry that incorporates the individualized case planning requirements under Title V to support youth and families while the youth is in the placement and post-release. Thank you for the opportunity to comment.
Thank you. Next caller.
Chair, there are no additional callers choosing to testify at this time.
Thank you. Then I will welcome the sponsor back up for any final remarks.
Thank you, Chair. Lisa Cole for the record. I know that Ms. Duffy would like to also have a closing statement, but I just wanted to say again, thank you very much for the opportunity to present this. And I truly do look forward to working together with the stakeholders and with Chair to make sure that the language here works for everybody and it really does accomplish the goal. Thank you, Ms. Duffy.
Assembly member, would you like to comment on, remember that little conversation we had about Washoe before committee started today?
Yes, and I actually do appreciate that Ms. Suarez called in because thank you for reminding me. In my research and conversations thus far, and especially yesterday, I found out that Washoe County actually does have a very good program for reentry, and I think that we can work together with her and the department to make sure that my language is modeled off of what they're doing currently, since it is in practice and working well. Thank you.
Thank you. Ms. Duffy.
And thank you again, Chair Miller. Bridget Duffy for the record. I recognize the struggles that our Division of Child and Family Services has with having only three facilities and limited amounts of beds. But we have had situations in Clark where superintendents have determined that a child is not appropriate for any of the facilities. And so this bill will at least, provide a statute that has them tell us why they've deemed them inappropriate. Let the court have that information. And most of the time what we find is they're more appropriately suited for a mental health facility, which also then, in my opinion, would land on the administrator of the Division of Child and Family Services, whoever that may be at the time. And when you hear about what my colleagues in the public defender's office stated about a child who's gaining 40 battery charges while in detention in Clark, if it's a simple battery, we're not recharging the child. There's no flat sentences. It's, you could admit to 10 felonies in the juvenile court, and the highest level of treatment we give you is an average stay of 6 months at one of our state facilities. So it's not, you're going to serve 2 to 10 years for 10 felonies. We're programmatic based. So in Clark, at least, a child who's acting out in detention, we're not just charging and adding charges because it ultimately doesn't matter. What that triggers is a mental health problem that needs to be addressed. And the court needs that information to know that, so that the court in its discretion can do what we've charged the court to do, which is to make sure that these children get the right rehabilitative services to improve the safety of our community. I really do appreciate you taking the time to listen to this bill, as I believe it is a piece to the almost unsolvable puzzle of how we can help kids get on the right path and trajectory and stay in the juvenile system across our state. So thank you very much.
Thank you so much. And with that, I will go ahead and close the hearing on Assembly Bill 384. Next, we have Assembly Bill 488. So I will open up the hearing on 488. This bill revises provisions relating to criminal convictions of certain victims. And again, I'll give you a few moments to get settled, and whenever you are ready, please proceed.
Good morning, Chair Miller, Vice Chair, and members of the Assembly Judiciary Committee. My name is Tia Smith, T-I-A-S-M-I-T-H. I'm a policy attorney with ACLU of Nevada. I'm joined by ACLU of Nevada Executive Director, Atara Hasibula. Thank you for the opportunity to present Assembly Bill 488 this morning, which revises the process by which survivors of human trafficking may petition to vacate and seal their records on their criminal convictions that were the direct result of their victimization. The bill represents another critical step towards justice and healing for trafficking survivors who were criminalized for conduct that they were forced to do due to coercion and abuse. By further modernizing Nevada's law, AB 488 ensures our law reflects the realities of human trafficking and the need for trauma-informed relief. Nevada has over 5,000 people sold for sex in an average month. Survivors of sex trafficking frequently face additional criminalization for acts committed as a direct result of being trafficked, such as drug trafficking, identity theft, and credit card theft. A 2023 national study revealed that 62% of trafficking survivors had been cited, arrested, or detained by law enforcement, with 71% acquiring a criminal record as a result. Despite being victims, many are arrested, charged, and convicted for these acts. These convictions can follow them long after they've escaped trafficking, creating lifelong barriers to employment, housing, education, immigration relief, child custody, and personal safety. This criminalization blames the victim instead of the trafficker. AB 488 further seeks to correct that injustice.
AB 488 aligns Nevada with national efforts to ensure survivors are treated as victims and not criminals. As of 2020, over 40 states and U.S. territories have vacator or expungement laws for trafficking survivors. The U.S. Department of State, in their 2024 Trafficking in Persons report, recommends that authorities implement effective policies to ensure victims are not inappropriately penalized solely for unlawful acts committed as a direct result of being trafficked. These laws have bipartisan support across the country, with lawmakers increasingly recognizing that trafficking survivors should not be punished for crimes they were forced to commit. Nevada has had a vacator statute since 2017, and while well-intentioned, it needs to be expanded from a practical perspective. Under the current law, relief is limited to certain offenses that include prostitution or solicitation for prostitution, any nonviolent crime, or a violation of a county, city, town ordinance for loitering for the purpose of solicitation or prostitution. There is no mechanism for retroactive relief for older convictions, and survivors must bear the burden of proving their victim status, even if they have been recognized already by credible authorities. The result is that fewer survivors are able to access the relief that they need and deserve. AB 488 addresses this by expanding eligibility and streamlining the process. So now I'll do a technical walkthrough of the bill, starting with Section 1, subsections 1 to 2. This expands the eligibility. So under existing law, as I said, relief is limited. AB 488 expands eligibility to any state law offense or local ordinance violation, so long as the conduct was a result of human trafficking. Petitioners do not pay a filing fee and must notify the prosecuting agency. Subsections 3 through 6 go through the procedure and evidence needed. The petition must include a certification by the survivor and supporting facts. Official documentation or a statement from a qualified third party creates a rebuttable presumption of victim status. The court must determine whether the petition states a prima facie case, and if so, a hearing is held. At the hearing, the petitioner bears the burden to show by a preponderance of the evidence that 1, they were a victim of human trafficking at the time of the offense, and 2, the offense was a direct result of their victimization. If successful, the court shall vacate the conviction, dismiss the charges, and seal the record. Subsection 7 through 8 just makes some conforming changes. Subsection 9 protects against retaliation, so prohibits any government agency or individual from retaliating against someone for seeking relief under this law. Subsection 10 has to do with data reporting, so the Administrative Office of the Courts must report to the legislature every 2 years on the number of outcome and positions. Subsection 11 provides some definitions. It has 4 definitions in there for governmental entity. Let me look at it real quick. So governmental entity encompasses an institution, board, commission, bureau, council, department, division, authority, agency of the state. Official documentation is also defined. Official documentation means a certified record from a governmental entity documenting the petitioner's status as a victim. It could also be a written affidavit signed by a qualified third party in their official capacity, stating that the victim had sought assistance from them or that they were a victim of human trafficking. It also encompasses any evidence, reports, statements, other materials which the court determines to be legally sufficient. It also defines qualified third party, and so this can be a physician, a psychologist, a therapist, a counselor, a registered nurse, or anybody who is employed by an agency or service which advises persons regarding human trafficking. It could also be any member of the clergy of a church or religious society or denomination. And then finally, victim of human trafficking is defined. It refers to a few different NRS statutes and U.S. Code. So those include involuntary servitude, trafficking in persons for illegal purposes, pandering and sex trafficking, living from earning of prostitution, forced labor, trafficking with respect to peonage, slavery, involuntary servitude, or forced labor, sex trafficking of children, or by force, fraud, or coercion. Those are the definitions in there. And then with Section 3 provides retroactive relief. The bill applies to convictions obtained before, on, or after the bill's effective date, ensuring that no survivor is excluded due to the timing of their case. Assembly Bill 488 is another powerful tool for justice, healing, and opportunity. The bill centers the realities of survivors' experiences, provides meaningful relief with procedural safeguards, and further affirms that Nevada stands with survivors, not against them. This is not just a policy fix, it's an act of restoration, an opportunity to say, you are not a criminal, you were exploited, and the law continues to recognize that. With that, we will take any questions. Thank you.
Thank you so much. I will give members a moment to, and we already have one. Our first question will come from Assemblymember Gonzalez.
Thank you, Chair, and good morning. Thank you so much for your presentation. I was wondering if you could talk about any examples or instances of this happening here in our state.
Good morning. For the record, Atar Hasibullah. First name spelled A-T-H-A-R, last name H-A-S-E-E-B-U-L-L-A-H. I'm the Executive Director for the ACLU of Nevada. If I can go directly to the Assemblymember Chair. Assemblymember Gonzalez, we are aware of specific instances of this happening, including individuals. I know of at least 2 instances of individuals who have been sentenced to periods of incarceration for crimes that occurred during their pendency as a survivor of sex trafficking. For context as well, background-wise, I had started my career as a juvenile sex crimes prosecutor in New York City, and then I spent about 4 years at Legal Aid Center of Southern Nevada dealing with many of these issues, including providing assistance to survivors of trafficking as well. As it stands right now, I can point to one instance, and I won't go into too much depth to protect the confidentiality of what occurred there, but someone who was 18 years old that was charged and convicted as an accessory to a robbery while her pimp and others who were decades older than her committed a robbery and a home invasion. She was sentenced, convicted of robbery, sentenced to a period of incarceration for up to 30 years. This is someone who the science that we have when we're discussing the impact of human trafficking and sex trafficking on survivors and victims, the legal system hasn't caught up to her because the mechanism for relief in terms of disqualifying nonviolent offenses precludes that. Now, our position at the ACLU is that if you're committing a crime under duress and you're not in a position right now where you're in a scenario where you can clearly object to what's occurring because you're still afraid to come forward to a court and share your story, you're afraid to tell prosecutors, law enforcement, or anybody else what happened, you may find yourself in a position where you're sentenced in an excessively harsh fashion. But in the last few decades, we've worked to really do better about this all across the country, and that includes here in Nevada. The disqualifier for violent offenses and only allowing this to occur for nonviolent offenses ignores reality, which is in many of these instances, pimps are not sending someone out to commit a petty larceny. They're sending somebody out to commit or participate as an accessory to a robbery or something that may be violent, but they're still operating under duress. And the reason why we have other elements here, including being able to seek documentation from your clergy in support of this and changing the presumption nature, is because of the notion of delayed disclosure. Many of these survivors come forward years later, and they're able to share this, and we knew this was happening at the time, but again, the legal system hasn't caught up to the people impacted by the same system. So we're aware, and I'm sure if the anecdotes aren't comprehensive, perhaps those that are providing opposition testimony will be able to share more real-time data that they may have if there's a fiscal note that they're going to attempt to put on this in any form or fashion. But that data may be something that they possess, and they may be able to share how pervasive this is and how many folks this would apply to. Thank you.
Thank you so much. Our next question is from Assemblymember Cole.
Good morning. Thank you for the presentation. So my question is in regards to, Section 1, 3C3, I think it would be. It's on page 5, where we're talking about the ability of a member of the board of directors or serves as the executive director of an agency or service which advises persons regarding human trafficking or refers such persons to persons or agencies where the requested needs can be met. These are qualified third parties. So my question is there any concern or would you consider adding in language where it has to be a group that's recognized as a legitimate group? I can just see this being something where, you know, a human trafficker or a pimp, if you will, would set something up like this, and somehow that works in a really weird way. Thank you.
For the record, Atar Hasibullah, ACLU of Nevada, Assemblymember Cole, we'd be happy to consider any modifications along the way. You know, the main thing is we want to make sure that our laws are catching up to the reality of what's happening on the ground. I can also tell you from a practitioner standpoint, and there may be others who agree or disagree, oftentimes in these types of instances, there's not always a vested interest from a pimp to have someone released, especially somebody that they may have trafficked at some point. So I don't know that it would happen in that context, but we're certainly happy to come up with language and modify any language that needs to make sure all the safeguards are in place. Again, this notion of duress and delayed disclosure is what prompted this specific language to come forward.
Thank you. Our next question is from Assemblymember Urick.
Thank you, Chair. And I also applaud and appreciate the effort, folks that have been victims of human trafficking, being forced to commit crimes. Obviously an issue that I think we want to address. I think the big concern is obviously, could this be exploited? Could it be used in a manner that would help folks avoid accountability? And so my question is on the sealing of these records to ensure that there is a nexus, right, between the sex trafficking or the human trafficking and the crime that they were charged with. The idea that is it possible that we could engage some sort of waiting period, right, to ensure that there is, like, you know, if it's just immediately sealed and they re-offend, there's with the sealing or no notification to the repository, is it possible that we would be overlooking repeated crimes that could then just be, again, exploited through this process? So have you thought through the possibility of just ensuring that there is a way for the system to identify folks that might be abusing this by either delaying or providing or instituting a waiting period or allowing courts to review those sealed records to see how many times this has happened before?
For the record, Atar Hasibullah, ACLU of Nevada, Assemblymember Urick, it is something we considered and we discussed internally. Again, not sure how pervasive that would be, because there's still a burden that does exist here in order to fulfill the process and move forward here. We think it was largely sufficient, but I know we've spoken to a couple stakeholders. We're going to be working with them on language specifically surrounding the sealing. And again, this entire process isn't simply automatic, that somebody receives, you know, a document from this outside entity and that's it. Their conviction's gone. Their record is now sealed. It creates a process for them to be able to challenge this, but it does burden shift in this fashion based on effectively the data that we've received over the years, which is that there is delayed disclosure that ends up existing. Certainly there's considerations there, but we will be working on some of those portions probably in the next few days. We had a couple concerns. We also are not attempting to make this a more onerous process for anyone. Unfortunately, the reality, as you all know, is sometimes when we enact law in Nevada, even when it's well-intentioned, it tends to create a new burden. So we're hoping to prevent that. So we've been talking to some of the practitioners in that space to make sure that there's no additional burdens that are placed, but also that the guardrails that are in place are sufficient. Thank you.
Thank you. Our next question is from Assemblymember LaRue Hatch.
Thank you, Chair. Thank you for bringing this morning. So you actually are leading right into my question of, can someone just use this as a get out of jail free card? They get arrested and then they, you know, cry wolf and then they're out. I mean, it doesn't seem like that to me, but I wondered if you could just walk us through, what do you have to prove so that you can't just state, I'm this person without any proof?
Tia Smith for the record. Thank you so much for the question. So the court has to do this kind of on a case-by-case basis, and so they have to see all the evidence coming in and be able to make that determination if there is a nexus between the crime and them being a victim of human trafficking. So with the requirements that the court need, they do need some evidence, right? It's not like somebody's just coming up and saying, I'm a victim, please let me go. They do need some evidence, and if they don't have any actual documentation or anything, they can go to the court and explain their story and tell the judge, and the judge can make that decision if they think that there is that close enough nexus that they were truly a victim and they truly committed that crime out of duress.
For the record, Atar Hasibullah, I'd just add that there's already a petition process that's in place. The petition process isn't going away. The burden has been reduced, and it's removed a disqualifier, right? The violent crime versus nonviolent crime portion is the biggest element here. It's not sensible to say that someone was under duress, so they committed crime A. But if they're under duress for committing crime B, we're only going to punish or allow for relief in one instance versus the other. If you're under duress at that time, you're under duress. And so there's still a process, and a court's still going to end up making a determination in this instance. You can't negate that process, primarily because just technically and logistically it's not feasible. But when it comes to being able to move forward with the process, it does it expands the categories for those that would be eligible. Again, they still have to fall under the category of being a human trafficking survivor, as was described and my colleagues as referenced in the sections there that were applicable. But the petition process would actually allow for the additional category. And from an ideological consistency standpoint, we find that to be very, very important, and notwithstanding the fact that from a practical perspective, each of these factors would need to be considered. A court will still be able to make that determination afterwards. And this kind of goes into, I think, Assemblymember Urick's question a few moments ago. When we start looking at guardrails and safety, the court's going to end up making considerations on a number of things, but when we discuss crimes that have occurred that people have been convicted for, really those are going to be viewed in the context of that individual crime and what was occurring at that time. These documents are still going to need to be provided to the court, and those courts are going to still need to exercise discretion just as they're doing now. They'll just be able to do it with additional categories that are applicable to real people in real time and real survivors that have faced these very real issues.
Thank you. Assemblymember LaRue Hatch, did you have another question? I do, yes. Okay, go ahead.
Thank you so much, Chair. I do have a second question, and I really appreciate that answer. My second question is just on the qualified third parties. I noted, there's obviously physicians, nurses, counselors, clergy, and that made me wonder, could teachers perhaps qualify as well? I know that not all of these victims are going to be high school age, but some of them will be. Maybe some of them will be at a college level. Is there any discussion of whether or not that's appropriate to include them as a qualified third party?
For the record, Atar Hasibullah, ACLU of Nevada, Assemblymember LaRue Hatch, I'd love to see this expanded to many categories over. I think what we wanted to do here was make sure this was partially limited to some extent to make sure at least there were certain provisions in place, primarily in the context of delayed disclosure and those that have been charged. I'm not, again, clear on how many times this might end up coming up in those instances, but would certainly happy to consider that. I'm also mindful of the restrictions that are often placed on educators and what ends up becoming required disclosure afterwards and things of that nature. And certainly we thought this list was pretty comprehensive. It's not something that we'd be opposed to in any form or fashion, but we did want to take that into account. I think when we went through this, the categories of those we've spoken to and the practitioners who we consistently deal with who end up handling these types of issues sort of went through this, and more often than not, I think the scenario that would end up popping up is actually falls to your point under category 4. Just folks often end up feeling comfortable with clergy, and they may end up feeling comfortable with educators in the same way. So certainly happy to consider adding that in if we think that there's value in doing so.
Thank you. All right, right now I don't see any additional questions, so I will go ahead and open it up for testimony. Beginning here in Carson City, anyone that would like to testify in support of Assembly Bill 488.
Good morning, Angela Knott from the Washoe County Public Defender's Office. We are in support of AB 488. We in general support any kind of bill that will provide support and help to anyone who's a victim of sex trafficking. And the way I've been reading this bill, just based on my own practice, this isn't an easy thing that's going to be accomplished. This will take like the energy and the trust and the will to go in front of a judge and share their story about what happened to them. This is not going to be an easy task for anyone to do. And I think what stood out to me the most on this bill, especially when we're talking about stigma when it comes to victims of sex trafficking, is subparagraph 9 on page 4. A person or governmental entity shall not discipline, penalize, or otherwise retaliate against the petitioner for filing a petition pursuant to subsection 1. That is a powerful subsection, and I think it shows what these women, I say women, I know men can be victims also, but what they go through and what they're still going through even after they have escaped the torment of being a victim. So for those reasons, we are in strong support of AB 488. Thank you.
Thank you so much. And can you spell your name for the record? I know.
So close. Angelaknott. Thanks.
Thank you, Chair, members of the committee. Harrison Epstein, legal extern for the Clark County Public Defender's Office. That's HARRISONEPSTEIN. First thing we'd like to do is echo everything our counterpart in the Washoe County Public Defender's Office just said. We do believe as well that this is an incredibly important bill. Expanding and simplifying the process for victims of human trafficking to seal criminal records is an important step in making sure that we are eliminating barriers for people to succeed in life. The more that we can do for victims now, the better we ensure that they don't come through the criminal legal system later. Thank you.
Thank you. Is there anyone else here in Carson? I don't see anyone in Las Vegas, so broadcasting, would you open the lines?
Thank you, Chair. If you would like to testify in support of Assembly Bill 488, please press star 9 to join the queue.
Good morning, Chair and members of the committee. My name is Paula Luna, Paula Luna, and I'm the Deputy Director of Battleborn Progress. I'm calling in support today of AB 488, and I want to echo the statements made by the bill presenters and urge you all to support. Thank you so much.
Thank you. Next caller.
Good morning, Chair and members of the committee. My name is Riley Swenson, RYLEYSVENDSEN, and I am the Policy Specialist with the Nevada Coalition to End Domestic and Sexual Violence. We support any legislation that is victim survivor centered, that reduces barriers, and that is focused on healing. As such, we urge you to support AB 488. Thank you.
Good morning, Chair Miller and members of the committee. My name is Denise Bolaños Heredia, BOLANOS HEREDIA, and I'm the Associate Director of Return Strong, an organization dedicated to advocating for the rights and dignity of incarcerated people and their families in Nevada. We strongly support AB 488. We echo the comments made by the bill presenters and others that have commented in support ahead of us, and we urge you to pass this bill. Thank you.
Good morning, Chair and Committee. This is Ashley Dodson, for the record, ASHLEYDODSON, calling on behalf of the NAACP Las Vegas, Chapter 1111, in full support of Assembly Bill 488. This legislation will bring long overdue justice, dignity, and healing to survivors. For decades, victims of human trafficking, predominantly women and girls of color, have been arrested, convicted, and marked with criminal records for actions they were coerced or forced to commit while under the control of traffickers. These convictions have not only added trauma to already devastating experiences, but have also created long-term barriers to employment, housing, education, and recovery. AB 488 addresses this harm by expanding the opportunity for these victims to petition for the vacature of convictions and the sealing of associated records. We urge the committee to pass AB 488 without delay and move forward a vision of justice that affirms, restores, and protects our most vulnerable. Thank you for your time.
Chair, there are no additional callers choosing to testify at this time.
Thank you so much. Then I will open it up for opposition testimony beginning here in Carson City.
Good morning, Chair, members of the committee. My name is John McCormick, John, last name McCormick, MCCORMICK, Assistant Court Administrator at the Supreme Court. I'm here to speak exclusively to Section 1, Subsection 10 of this bill, which requires the Administrative Office of the Court to report certain data elements. Currently, the way this bill is written, we are faced with a choice under this bill to abandon our ongoing initiative to develop a data repository as a long-term fix to get better data out of the courts and allow some level of reporting. However, the way this bill is written, it requires individual level reporting upon passage and approval, so we will have to refocus our limited existing staff to going out to courts and collecting individual case outcomes through case review. So it does place a significant burden on our ongoing data collection efforts. Thank you.
Thank you. And Mr. McCormick, so just to clarify, your opposition is for the technicality of that process, not for the overall conception of the bill.
Thank you again, John McCormick, for the record. Yes, my concerns are exclusively related to the way the bill calls for the data collection to be implemented and conducted. Thank you.
Thank you so much.
Good morning, Chair Miller and members of the committee. My name is Lauren Boytel, Lauren Boitel, and I'm the co-founder of the Nevada Policy Council on Human Trafficking. We truly appreciate the commitment to ensuring that victims of trafficking are not criminalized, but we are here to express our opposition to portions of AB 488 in its current form due to the burden it places on survivors and the risk of further trauma it introduces. While the bill intends to assist survivors in clearing their records, it requires them to independently petition the court. This adds an additional and significant burden on victims who are already navigating the emotional and logistical challenges of rebuilding their lives. Under current law, the court provides notice, reducing the responsibility on victims. AB 488, by contrast, forces survivors to take on this task. Victims should not face higher burdens in this process. Additionally, the bill requires petitioners to provide facts that support their case. This is not a trauma-informed approach. Survivors would be compelled to rehash the horrors they endured at the hands of their traffickers in order to qualify for relief. This is re-traumatizing and likely to discourage many from pursuing the very relief the bill intends to provide. Many survivors will find it difficult to relive their abuse in such detail, and this could prevent them from taking the steps necessary to protect their future. Furthermore, if there is no documentation, the bill requires mandated court hearing. This public process forces survivors to confront their trauma in an open forum, something many survivors struggle with, which is why they often do not cooperate with criminal investigations in the first place. We must remember that the majority of victims remain hidden and silent due to the fear of public exposure and retaliation. Requiring them to appear in court and publicly share their trauma will only deter them from seeking the relief they need. At the Policy Council, our mission is to advocate for just and equitable policies that support victims and survivors and improve the system overall. Portions of AB 488 as written run counter to these principles, creating an unnecessary obstacle for survivors. We urge reconsideration of these provisions of the bill that require victims to navigate this process and look forward to amendments that remove these burdens. Survivors need access to trauma-informed support and protections, not further victimization. Thank you for your time.
Thank you so much. Anyone else here in opposition? Not seeing any, and there's no one in Las Vegas. Broadcasting, will you open the lines?
Thank you, Chair. If you would like to testify in opposition to Assembly Bill 488, please press *9 to join the queue.
Good morning, Jennifer Noble on behalf of the Nevada District Attorneys Association testing in opposition to AB 488. I'll begin with some context. In 2017, we assisted then Majority Leader, now Attorney General Aaron Ford, on SB 125 and agreed to shorten the waiting period applicable to the sealing of violent crimes by 1/3. For nonviolent crimes, the time was cut by over half. In 2021, the legislature passed AB 219, which provided that a person convicted of prostitution, solicitation for prostitution, or any nonviolent offense could petition to have their record sealed, regardless of the usually applicable waiting period, if their participation in the offense resulted from being a victim of human trafficking. But AB 488 greatly expands the crimes eligible for this expedited sealing, placing no limitation or waiting period even when the offense is violent and not perpetrated on the pimp or the sex trafficker. Under its rubric, crimes like assault with a deadly weapon, kidnapping, armed robbery, and even homicide would be eligible for sealing without the applicable waiting periods that were again shortened in 2017. Once a conviction is sealed, it cannot be seen by prosecutors, the courts, or law enforcement, or potential employers, including employers who run facilities or programs where the offender would have access to children and vulnerable persons. In terms of establishing a nexus between the crime to be sealed and the petitioner's status as a victim of sex trafficking, Section 11 of the bill lists qualified third parties whose affidavits operate to serve as evidence of the nexus between the crime and the crime to be sealed, and the petitioner's status as a victim of human trafficking at the time. But these third parties may have to rely entirely on self-reported information from the petitioner. The proof the bill contemplates is reliant entirely on self-reporting, which leaves it vulnerable and the sealing process vulnerable to abuse by violent offenders who are in fact not victims of sex trafficking, who could misrepresent their circumstances to the bill's well-meaning and important qualified third parties that provide services to victims.
Thank you. Your time is up.
Okay, thank you.
Thank you. Next caller.
Good morning, Chair, members of the committee. Jason Woodard, Jason Woodard, Nevada Sheriffs and Chiefs Association. We are opposed to AB 488 for the reasons cited by the NDAA and agree with the concerns they brought forward in regards to this bill. Thank you.
Thank you.
Chair, there are no additional callers choosing to testify at this time.
Thank you so much. Then I will open it up for testimony in neutral, beginning here in Carson City.
Good morning, Chair and Vice Chair Committee. Jessica Glover, Jessica Glover. I'm in neutral for AB 488. For nearly 10 years, I was human trafficked. During that time of being arrested and the times that I had sent in the CCDC, women glamorize the crimes, such as robbing their tricks. One woman even shot another woman over a John. So there's a difference in crying wolf and then being manipulated because you think that your pimp loves you and you're going to commit crimes. So I'm in neutral because there is a difference in people being abused and others crying wolf. Thank you.
Thank you. Anyone else here in Carson City? Not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
Thank you, Chair. There are no callers to provide testimony at this time.
Thank you. Then I will go ahead and welcome the bill sponsors back up, or bill presenters. The Judiciary Committee is actually the sponsor, but the bill presenters for any additional comments.
For the record, Atara Sibul, ACLU of Nevada, I just want to thank the committee for hearing this bill. Obviously, the concerns that were raised during opposition, some, these are sort of usual ones we expect in many instances. It won't go far enough in one direction or won't go far enough in another direction, but we remain committed to working with anyone who has input here to make sure the bill is as good as possible. I'd also just mention, if we find ourselves wedged in a battle between making sure that the bill is good and the bill's perfect, we're hoping that this goes a long way. We know it's not going to be the greatest thing since sliced bread, but for those that we end up dealing with who have been placed in a system of incarceration for a period of years under duress, this bill would go a long way to helping them. They would call in and testify in support if they weren't subject to retaliation, but they remain concerned that they will be. So for all of those silent voices that we also represent, we wanted to thank this committee for taking this bill up as a committee bill, and we do appreciate you for doing that. Thank you.
Thank you so much. And I will go ahead and close the hearing on Assembly Bill 488. Our last item of business today is public comment. Is there anyone wishing to make public comment here in Carson City? Again, just a reminder, public comment is not to discuss the bills that were presented today, but for anything else under the purview of this committee.
Good morning again, Chair and Vice Chair and Committee. In 2017,
Please restate your name and spell it.
Sorry.
Thank you.
Jessica Glover, Jessicaglover. In 2017, 2018, when I was able to flee my abusers, my traffickers, after getting attacked in a Lake Tahoe resort and being denied to being safe by people that take an oath in law enforcement to protect and serve, and being victimized, being re-victimized over and over since 2018, going before a judge in Douglas County and telling my story of what has gone on in my life, and being told that I'm a liar, being told that you can either go to prison or do mental health court, because they didn't want to believe my story. These are police reports from the Sparks Police Department. Since 2021, my abusers have been trying to re-traffic me. I'm done being silent. I will not be quiet, and I will keep fighting for justice for all. Thank you.
Thank you so much. Is there anyone else here in Carson City? Not seeing anyone here or in Las Vegas. Broadcasting, please open the lines.
Thank you, Chair. If you would like to provide public comment, please press *9 to take your place in the queue. Chair, the public lines are open and working. However, there are no callers choosing to provide comment at this time.
Thank you so much. Well, with that, that concludes our business. So I will go ahead and close public comment and adjourn for today. And I will see you all back at 8 a.m. Thursday morning. Yes, I said Thursday. Thursday. Unless you have any, the whole room is like standing up, like you are. Unless anyone has any opposition to that. Okay, then I'll see y'all back Thursday at 8 a.m. This meeting is adjourned.